this morning's docket. It is case number 108563 in the matter of Thomas.
My name is Elbridge Griffey. I am representing Cody A. Thomas. This is a petition for review. I would ask for 3 minutes to be reserved for rebuttal.
3 minutes is granted.
Mr. Thomas was committed to Larned State Hospital under the Kansas Sexually Violent Predator Act. We are seeking review of the Court of Appeals decision upholding the admission of medical testimony based on hearsay statements, which also violated his right to cross-examine and confront the accusers under the Sixth Amendment and due process clause of the 14th Amendment. Mr. Thomas also challenges the district court's instruction to the jury, which was upheld by the Court of Appeals, which we believe violates the state's burden of proof under the due process clause of the 14th Amendment, and it's also in violation of the state statute.
Counsel, let me start out on the confrontation hearsay issue with Dr. Shannon's report. My review of the record and the briefs would indicate that no objection was made to Dr. Core's evaluation, references to the nursing notes, and the written report that Dr. Kors did. Is that correct?
Your Honor, I do not believe there was a direct objection at that point in the trial.
And that covered all the same material that Dr. Shannon covered as well, correct?
I believe that is correct.
And when Dr. Shannon's written report was offered into evidence, you told the court no objection to the admission of that report, correct?
That is correct.
So how do we look at any error from Dr. Shannon's report? I don't see where you protected these particular issues for appeal.
During the early part of the trial, when Dr. Shannon was called onto the stand, I made objections when he started to verbatim recite information that was contained in nursing reports, staff reports, and my initial objection was that it was hearsay and it was a violation of the confrontation clause under the Sixth Amendment.
But the cat was already out of the bag because Dr. Kors had done the same thing and produced a written report that contained the same material and, frankly, the same opinions, and there was no objection.
My recollection is Dr. Kors' material came in after Dr. Shannon. It was before. It's been long enough. All I can say is I don't have an explanation for that. And the trial was long enough ago that my recollection was that Dr. Shannon had come in and I tried to make an objection, and Mr. Branson, the district attorney, had made the statement to the court that based under the new Kansas statute, the Sexually Violent Predator Act, that they were allowed to recite information or rely on information that they received from the clinical reports or any of those things, even if they received them the day of the hearing. And Judge McCorney did not rule on my objection at that time.
But even if that's the case, when Dr. Shannon's written report is then offered into evidence, you indicate you have no objection to the report.
I don't have an explanation for that. Okay. I think that the entire issue, I felt like I had made an objection at some point, that the court never ruled on it. And to be quite honest, I don't think this is the strongest issue in our petition for review. I had hoped to ask the court to address issue 2 prior to coming back on issue 1, if that's a possibility at this time, because it doesn't sound like I'm going anywhere positive on issue 1.
Do what you want.
It's your 15 minutes, counsel.
Well, that would be my request at this time, because This is the first time I've argued in front of the Supreme Court, and looking at all the training manuals and getting information from other people that are experienced. One of the first suggestions that I received was try to figure out what the court's interested in and what might bring us before the court. And quite frankly, I don't think it was issue 1.
Can you lay the groundwork for me then on the instruction issue? I guess I don't understand how, with a PIC instruction out there on sexual predators, that the state wanted a modified instruction, and I understand that you wanted a modified instruction too. So what was the thought going into doing something outside of PIC?
Your Honor, the instruction that was given was a result of communication between the court and both opposing parties. I can tell you, quite frankly, the instruction that was given wasn't a part of any strategy on the part of the defendant or the respondent in this case. At the time it was given, I guess we felt that it was an appropriate instruction. I would suggest to the court that there were at least 3 other attorneys who were involved in getting this instruction and the judge to approve this instruction that felt like it was an appropriate instruction at the time.
You had no objection to the instruction that was given.
We made no
Are we in
objection.
clear error territory?
We're going to argue that basically it's clear error and it's structural error. And I think that was addressed in our petition. And to be honest, I don't know whether I can explain or get to the reason why this was the instruction that was given. It was approved by the court. The judge, as was mentioned in the previous argument here, in terms of what instruction is given to the jury, that's the judge's responsibility to instruct the jury. And if the judge gave that instruction, that's what was given.
Counsel, perhaps you could go to the structural error argument.
In this case, under SVP, sexually violent predator, the state's required to prove all the elements beyond a reasonable doubt that the accused or the respondent is being convicted of a sexually violent crime, that they suffer from a mental abnormality or personality disorder, that abnormality or disorder makes the respondent likely to engage in repeat acts of sexual violence, and that the mental abnormality or personality disorder makes it seriously difficult for him to control his behavior. The reasonable doubt instruction that was given in this case alleviated. There's 2 prongs in the reasonable doubt instruction. The state has the burden to prove its claim in this proceeding. The test you must use is this: if you have a reasonable doubt as to the truth of the claims required to be proved by the state, you must find for the respondent. What that clearly should have said is if you have any reasonable doubt as to the truth of any of the claims. The way that it's written, it means that the jury has to believe that they have a reasonable doubt to all of the claims before they could find him not subject to commitment. That's not a correct statement of the law. The second prong, if you have no reasonable doubt as to the truth of any of the claims required to be proved by the state, you should find for the state. Once again, that's not a correct statement of the law. The jury could commit the respondent if it has no reasonable doubt to any of the claims, any one of them that are required to be proved by the state. It's not a correct statement of the law. Based on that instruction, we cannot tell what the jury decided. And clearly, the wording in that instruction would permit the jury to convict without finding him guilty on all the elements.
Are you familiar with, the Court of Appeals cited the State versus Herbal. And then after that, last year, we decided Miller versus State. Are you familiar with that case?
I am, and I actually had a chance within the last 2 weeks to review and observe the Miller argument that was archived on the Supreme Court archive. And in fact, I can differentiate or distinguish between Herbal and the case at hand. In Herbal, I think that there was one error in the reasonable doubt instruction in the two prongs. There was one of them that was incorrect, one that was correct. In Herbal, the appellate court or the Supreme Court found that the elements instruction could make up for that shortfall in the reasonable doubt instruction. In this case, both prongs of the reasonable doubt instruction are incorrect. And it conflicts with the elements instruction that was given in this case.
Now, I'm not sure I agree with you on, in your case, that the elements instruction was wrong too. Where are you seeing that? I mean, I'm looking at it, and it says to establish this charge, each of the following claims must be proved, and then it lays out the three elements.
It conflicts with the second prong of the reasonable doubt instruction, where it says if you have a reasonable doubt as to the truth, if it has no reasonable doubt as to the truth of any of the claims, which is the second prong, that conflicts with the each element of the crime that's in the elements instruction.
Counsel, I think maybe we had just a miscommunication. You weren't saying that the elements instruction itself was in error. You were just saying it was in conflict with reasonable doubt.
Correct. Thank you for the correction. And because of that, it's being not a correct statement of the law. I think that it's very similar, and we would argue that it's just like Sullivan or Miller. There's structural error here. You cannot really tell what the jury's decided based on this instruction. And once again, the wording of the instruction clearly permits the jury to convict without finding on all the elements. My other issue with structural error as applied to a civil case, because Miller and Sullivan are both criminal cases, and we're dealing with a civil case here. There have been cases that have found there's a due process right in civil commitment cases when someone's looking at a loss of liberty, and clearly in these sexually violent predator cases, this can be a lifetime sentence. So we believe that there are due process rights that attach for Mr. Thomas here, and in fact, one of those most basic due process rights is the right to a fair trial. Similar to some of the argument that was had in the previous case that was before the court, with the instruction being this flawed, and I would argue that it can't be corrected by the elements instruction. It's a structural error that requires this case to be set aside because of that. You just don't know what the jury convicted him on. I mean, there are other reasons why I think that this structural error should be applied in this case. The similarities between the sexually violent predator statute and the criminal statutes, where you are entitled to a right to a preliminary hearing, you're entitled to expert witnesses, the burden is beyond reasonable doubt to a jury, the potential sentence is a lifetime commitment to a mental facility. It just seems to me that clearly that the structural error should apply in this type of case. And I do believe that there's enough differences between Herbal and this case that it can be distinguished based on the fact that there's just more errors in this one.
So you would be asking us to reverse and remand for another proceeding?
Yes, Judge.
All right. Any further presentation?
No further presentation.
Any more questions? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm going to start with the instruction issue. I don't think that there were 2 errors in the instruction issue. I will admit that the any should have been each. But the first one that said a reasonable doubt as to the claims, I think that just means one doubt. It doesn't mean multiple, and it can be any one of those claims. Well, of course, it would have been best to follow the pick in this situation. I don't think that that was a misstatement of law, and regardless of any error that may or may not have been in the instruction, the error here does not reach clear error.
Let's nail down the first part and then move on to the second.
Okay.
In Herbal, we said that there wasn't an error with the language because this is the way it used to be written back before, and it didn't match pick, but that was okay because we had approved it before. We can't say that in this case. This instruction, I mean, everybody made a mistake. I mean, there's no question. So there seems like there's error, okay? And so then I figured, and I'm trying to think about, well, what does it mean? And so it seems to me that this case fits somewhere between Herbal and Miller. And then it's just a question of how close it gets to Miller in this process. But just because it's error, is there a reason why it wouldn't be structural error the way we declared it in Miller? I'm trying to figure out if we can differentiate or if we can grade the degree of error
I don't think
in this instruction to see whether it's closer to Miller or closer, to Herbal, or are we just, if it's error, are we just in structural land?
Well, in Miller, what the instruction was if that they had to have reasonable doubt as to each and every claim that the state was making in order, and that is an absolute misstatement of the reasonable doubt standard. Here they only had to have one reasonable doubt. It says a reasonable doubt as to the claim. So I don't think it's equivalent to Miller or structural error. They say a reasonable doubt as to the claims, and then they go on to say no reasonable doubt as to any of the claims. To the extent that any is ambiguous in that definition, you can still look to the other elements instruction which says each and tells them they have to prove each and every one. So again, when the instructions are taken in their totality, the reasonable doubt instruction is correct. There's no structural error here.
And as I read Miller and remember Miller, we didn't have an elements instruction there. So we didn't have anything to look back on to correct. Is that right? I'm going from memory, and
I'm sure there was a elements instruction. I would
Okay, we
think
can
in
look.
Miller.
I can look.
I've never seen a criminal case without one, and that was a murder case. I have to hope there was one. If it is error, and then the clearly erroneous, I'm going to call it a standard, a shorthand, applies. Again, they were instructed each. The state has to prove each element. The 4 elements were listed. As aptly noted by the Court of Appeals, both attorneys argued that each of the 4 elements had to be proven. And the evidence in this case was overwhelming. I don't think there's any the appellant here has failed to meet his burden of proving that the error was reversible. Moving to the confrontation clause, unless there are any more issues on that. On the confrontation issue, the Court of Appeals found it wasn't adequately preserved. This court upholds that finding, then we're done there. If you overcome that somehow, there is no confrontation right in civil cases. I think that's a simple enough finding to make. Therefore, state would request that you affirm the Court of Appeals and the District Court in this case.
The 6404 finding by the Court of Appeals was sua sponte, wasn't it?
It was.
Okay.
But I believe that they were still right to get there, as they are allowed to uphold the court, or the district court, if the court is right for any reason. And KSA 6261, the harmless error statute, basically says you have to uphold if they're right for any reason.
Let me get back to your point that you made, that there's no confrontation right in civil proceedings, which is right in a generic sense, I suppose, but there's special protections in legislatures carved out most civil cases, you don't have to prove beyond a reasonable doubt.
That's true.
That's a big one. You don't have to have jury unanimity. There's others. Why doesn't then confrontation extend to that same thought process? I mean, as counsel pointed out, these are life sentences, essentially, on behavior that has yet to occur. So why shouldn't there be a protection through the confrontation clause?
The special protections that are enacted legislatively, and confrontation is not one of them. Also, throughout the country, this confrontation clause does not occur, or the right to confrontation does not occur in sexually violent predator proceedings, and part of that is because calling the original victim would be a problem. And so they have said, and I know in my brief, I laid out the 4 steps to determine whether or not...
Well, do you have to call the original victim? You're not retrying the crime, you're trying the behavior that could be exhibited in the future.
Right, but if
What
there's...
this is about is the reports and the documentations that's necessary to prove that. And why shouldn't the state have to produce the observer of the behavior or the scrivener of the report in cases like this where the result is
Because on the flip side of that, if they have a question as to any of the reports, if any of the reports done by Larned are inaccurate, they have the ability to cross-examine, they have their own ability to present witnesses. We're not precluding them from being able to prove that the reports are wrong. But the experts also rely on the police reports of the original crime. Most of the time, the original crimes are done through jury trials. So we can't have a plea agreement that we set forth, here are the facts of the crime. We just have the complaint. The police report is almost always used as the official version of the crime. And so if confrontation were to apply here...
So basically what you're saying, to confine someone for life, we shouldn't be required to have the state produce evidence as they would in a criminal case, which could result in the same kind of sanction. And in fact, here it's a deprivation of liberty that really is just unquestioned. Is that your answer here? That just because it's too hard?
Not that it's too hard. There's no authority to do so. There's no constitutional right to it. There's no statutory right for it. You'd have to create your own rule for which there's no precedent or authority to do so. Thank you.
Were there further questions? Just so I'm clear on some of the facts that were gone over with opposing counsel, there was an objection at trial to Dr. Shannon's testimony, which the court ruled on. But when it was time for his report to come in, there was no objection to its admissibility, so it was admitted. Is that right?
On Dr. Shannon,
Dr.
yes.
Shannon. And then for Dr. Coors, there was no objection to either the doctor's report or the testimony.
Correct.
And would you agree or disagree that the evidence contained in both doctors' testimony and reports were essentially the same?
Yes, they used the same reports to reach the same conclusions.
All right, thank you, counsel.
Thank you.
I had
Sure.
follow up on that. Did the court rule on the objection during Dr. Shannon's?
No.
So what's the effect of an objection that's made that's not ruled upon? Does
I'm
that
not
mean you still have to continue to object until the court will give you a ruling, or is it a continuing objection, or?
I do think that a objection that's made that isn't ruled on, I would still say is timely and preserved. That is as to Dr. Shannon's
But
testimony.
what effect, my question is, what effect does it have thereafter?
I'm not sure. I think you would have to continue to object to any new things that were by confrontation because the court hasn't granted a continuing objection. Here, Dr. Coors actually testified first, if I'm reading my record citation, and so Dr. Shannon was second. So all the evidence had already been put in.
And that makes it harmless. If there was
Right.
an error, it makes it harmless. It's
Right.
not a preservation problem, it's a harmlessness issue, right?
Correct.
Yeah, okay, thanks.
Any more questions? Thank you,
Thank
counsel.
you very much.
You reserve 3 minutes for rebuttal.
Just real briefly on issue one, if in fact the court has found that there was no contemporaneous objection made, I believe that there's still an avenue where the court may consider a constitutional issue raised, and the facts are not in dispute in this case. What the testimony was, what came in, I mean, that's undisputed. And additionally, there's a violation of state statute, and his right to a fair trial were violated. It's a life sentence case based on the damaging types of evidence that came in under the hearsay and without confrontation. I would ask that the court at least consider that issue. To go back to issue two, why this is structural error. It starts out from Ms. Chalmers' initial statements. They don't believe that the first prong of the instruction that was given, what does "of the claims" mean? Does that mean of any one claim? Does that mean all the claims? We don't know. And there are a lot of people smarter than me in this room, and I think there could be some argument to what that means to us and what that means to a jury. The state has also offered up that somehow this elements instruction, which correctly stated the law, can somehow make up for this flaw in this jury instruction. Once again, we're stuck with speculation about what the jury made this decision on, how they reached a reasonable doubt. You know, did they listen to the trial that Mr. Branson and I put on? Did they understand all those factors? We don't know. What's really relevant here is there was an instruction for reasonable doubt that was incorrect on both prongs. We don't know what the jury found him guilty of in this case beyond a reasonable doubt. And because of that, this case is much more like Miller and Sullivan, and there is structural error here. And we would ask that the court find that, and once again, that this commitment be set aside and that this matter be remanded for another trial. I can assure you that the objections, if I'm the one that tries this case next time, they're going to be handled in a different way.
Any more questions? All right, thank you, counsel.
Thank you.
We thank you both for your arguments this morning. The court will take this matter under advisement. This time.